Less than 24 hours after news broke of an order by the African Court on Human and People's Rights in favor of businessman Alfred Woyome, the Supreme Court of Ghana has delivered another decision against the businessman. The Apex Court has rejected the order made by the Regional Court directed at government to hold any process geared at retrieving the 51.2 million cedis judgment debt paid Mr. Woyome. The Regional Court on November 24 ordered that government puts on hold efforts to retrieve the money paid the businessman pending a determination of the case before the court. Lawyers for the businessman today presented the order hoping to hold all the processes, but that did not happen. JoyNews' Joseph Akable has more in the following report.
Two motions were before the court. The first was asking that the court stays all proceedings relating to repayment of the 51.2 million cedis. The second one again was a fresh one that was moved by lawyers for the businessman. They informed the court that they had secured a November 24 judgment directed at government, asking that government halt any attempt to sell any properties belonging to the businessman. So the lawyers had insisted that the court should arrest its ruling on a first motion that had been moved and hold on as the African Court on Human and People's Rights settles the matter currently before it. Deputy Attorney General Godfrey Adami opposed the two applications with regards to the second one and the latest order coming from the African Court. He had insisted that even though government had signed onto it and had it ratified by Parliament of the country, he said that it was important that those laws had to be incorporated into the laws of the country. Now, he said that once that had not been done, it meant that the government or the country was not bound by those laws, even though they will obey the court if it calls on them to appear before it. Delivering the judgment of the 5-member panel, a unanimous decision, Judge Senin Yeboah said the businessman had failed to show factually and legally any basis for the Apex Court to hold on. It again said that the Apex Court has jurisdiction on any matter in relation to the constitution of the country, and it will amount to allowing another body take over its functions if it were to hold on to proceedings. So it dismissed the two motions that were filed by businessman Alfred Woyome. Engaging the press after proceedings, Deputy Attorney General Godfrey Adami, who had told the court government had indeed signed onto the treaty, said they will go ahead to attach all properties belonging to businessman Alfred Woyome.
First and foremost, the ruling of the African Court came as a surprise to us. There was no hearing whatsoever. There was no notification to us of the proceeding. All that had been done was a motion filed by them. We had also filed our affidavit in opposition. And then there were no further representations whatsoever. So it actually came out of the blue. And if you look at the ruling of the African Court itself, it's indicated that they were represented and we were not represented. So how come they were represented and we were not represented? We think that something went amiss, something fishy occurred. But of course, we've crossed the barrier. The Supreme Court has done what is needed to be done, and we are very satisfied with it.
The other question is whether we are obeying the order directed at us saying that we should not attach the properties, that is government and the state as a whole.
No, I think 2 points are very relevant here. The first relevant point is that, as the court itself noted, and as I indicated in my submissions also, that is the Constitution of the Republic of Ghana, which is paramount. The government of Ghana does not, the government of Ghana is required to comply with laws set out in Article 11. And on top of that set of laws is the Constitution of Ghana. And so that is what we really go by. And in the same Constitution, it makes the Supreme Court solely and exclusively responsible for the dedication of constitutional matters. So that sole and exclusive jurisdiction of the Supreme Court in constitutional matters is not shared with any court, whether local or foreign. And indeed, that is what we go by. And it's again the same Constitution, Article 2, clauses 3 and 4, also directs that any decision or order of the Supreme Court must be duly obeyed and carried out. And it even sets out consequences which border on crime. So if a person unduly delays resort to subterfuge, plots, and ploys as this to evade judgment of the Supreme Court, that person's conduct is actually bordering on the commission of a crime. So let him go on and enjoy himself, but of course, definitely he will hit the wall.
So just to be clear, you continue to attach the properties?
Yes, again, yes, as I indicated, even the African Court of Human Rights itself, the protocol to establish that court must have been specifically incorporated into the laws of Ghana. And the process of incorporation into the laws of Ghana, the domestic law of Ghana, will require the enactment of an act of parliament. It is not new. You have the Geneva Convention. There's a Geneva Convention Act. There are various other protocols which are abided by an act of parliament, but this is non-existent. So, Woyome, as far as I'm concerned, is perhaps just biding himself in cycles. This decision of the African Court of Human Rights, as per common law, as per the Constitution of Ghana, as per even previous decisions of the Supreme Court of Ghana itself, must be specifically incorporated into the domestic law of Ghana before they can be applicable. And that is what these are the principles that will operate by.
What remains to be seen is the next step that will be undertaken by the Attorney General's Department after serving notice that they will ensure that the debt is satisfied by the businessman. Reporting from the Supreme Court, my name is Joseph Akable.
And we're joined now on the line by Nana J. Ewia. He is a private legal practitioner. Nana, thank you very much for your time here on the show. Now, are you surprised with the decision of the court?
No, I'm not surprised at all. I think that the Supreme Court simply asserted itself and its powers under the 1992 Constitution of Ghana. And so this morning, one of the sister station of yours did call, and I stated categorically that I would like to see the outcome of the interpretation. I'll be very surprised if it had gone otherwise. The Supreme Court, under the laws of Ghana, under the Constitution of Ghana, is the Supreme Court of Ghana, is the final court of Ghana. It doesn't follow the decision of any other court. It is sovereign in that regard, in respect of its power to make laws. It is sovereign. But
it is sovereign. But then when this obviously raises concerns when the state, has signed on to some of these international treaties and decides to disobey, so to speak.
Now, first and foremost, Ghana is a country of laws, and that even where the president or the government, following constitutional provisions or powers vested in it, signs an international agreement, which consequent upon which the parliament also approves of. It ought to conduct itself in accordance with the constitution of this country. Okay. So therefore, in the circumstance where a particular protocol has the effect, quote and unquote, and indeed practically amending the constitution, of course, due process of law would have to be followed. Okay. And therefore, in effect, when you say that the president has the power to sign a protocol which sets up, or a charter that sets up an international agreement, which he has gone on to do, right? Question it. Was it in accord with our constitution? That is what we are simply confronted with.
You reckon it wasn't?
No, I don't think it to the extent that it would have taken the powers of the Supreme Court. I think that it was not in accordance with the due process of law.
In that case, what are the options available to Ghana by way of redeeming, if you like, its reputation with the regional court?
It is not a matter of reputation. It's a matter of the regional court appreciating that we ought to operate within the tenets of the Constitution. Indeed, it's a court, and it also appreciates the fact that Ghana, being a democratic country, operates within or operates in accordance with the rule of law. I'll give you a very good example that would enable you to have a better appreciation of the situation. Now, when you look at the United Kingdom, for instance, they operate what we call parliamentary sovereignty. Now, parliamentary sovereignty simply means, in clear layman word, is that the law is as it comes from Parliament and nowhere else. And therefore, if Parliament says that tomorrow all women should become men and all men should become women, that is the law. And so, all that was required at the time, or in the circumstance of their membership of the EU, was for Parliament to make that decision. And indeed, if you do recall, recently after their referendum, it still came up that notwithstanding the decision of the people that they should cease to be members of the EU, they still require parliamentary approval. And so therefore it underlines the principles of parliamentary sovereignty. And so all that the English people required was for Parliament to say you are part of the EU, subsequent to which the Supreme Court of England currently and then the House of Lords is to be the final court of adjudication for the English people. They ceded that power to the European Court of Justice.
Okay, so let's come.
Ours is different. Ours, the supreme law of the land is the Constitution of the Republic of Ghana.
Right.
And therefore, if you are going to sign any international protocol, notwithstanding the fact that you have the power, that power is subject to the Constitution. And it was the case which the Supreme Court simply made in the Guantanamo Bay detainee case, that power to sign and ratify treaties are simply subject to the Constitution. Now, you go and sign an international agreement which invariably, right, establishes a court. That court, what is the extent of the power? What is the extent of the power of that court?
But once the countries within the region have agreed to, sign on to the convention that this regional court has, then they should be able to sort of follow
it doesn't
in that
matter.
regard. It doesn't matter?
It doesn't matter. What matters in the circumstances whether or not they did so in accordance with our Constitution. The Supreme Court is simply saying that, look, you've gone to sign it.
So the Attorney General, sorry to interrupt you there, but the Deputy Attorney General was saying something about not being present, that they weren't available when this decision was made. Would it have made any difference if they were informed?
Who was informed?
The Deputy Attorney General was just saying that they were not represented when this decision was.
That would have been as a matter of choice for the government.
Okay.
But even if they were present and the decision was made, they still could have disregarded it because of the nature of the Constitution we operate.
Right. Okay.
Invariably, or technically, that ratification sought to amend our Constitution by limiting the powers of our Supreme Court.
Okay.
Or if you like, transferring some of the powers of our Supreme Court.
Okay.
Or subjecting it to that of the African Human Rights and People's Court.
Okay.
And that requires amendment of our Constitution. It does not require the approval of Parliament. I mean, our judiciary is independent, particularly our Supreme Court when it comes to the interpretation of the enforcement and interpretation of our Constitution.
Because of time, let me just find out from you if this leaves Mr. Woyome with any options, I mean, from a legal perspective.
Really and truly, I think he has come to the end of the road.
Okay. We'll say a very big thanks to you, sir, for your time here on the show. I've been speaking to Nana J, where he's a private legal practitioner, speaking on the issue. For him, or if based on his discussion or his analysis, Mr. Woyome has hit the end of the road. We'll see how that development goes in the coming days. In the meantime, an Afrobarometer survey conducted by civil society group Center for Democratic Development, CDD, has indicated that most Ghanaians want tougher punishment to be meted out to corrupt officials who are found culpable of corruption. The survey, conducted between July and September this year, again saw the police topping the list of corrupt officials engaged in the Abominable Act. Interestingly, figures for traditional authorities and religious leaders found to be corrupt have also shot up. Hannah Odame has been speaking to Senior Research Fellow at CDD, Kudwa Sante, on other aspects of the survey centering on immigration, illegal small-scale mining and political vigilantism.
Really striking was the high levels of, perception of corruption in a whole host of institutions and leaders. That is very high. I've not seen that high, such numbers for a long time.
Talking of such, the police topped again this time in the formal sector and informal sector, traditional leaders, which may sound surprising, but not really surprising, isn't it?
Yeah, but this is the first time we've seen such high numbers for traditional authority, and it means that the situation has been worsening over a long time, because people had a lot of deference for traditional authority, but increasingly it means that they are also not getting the kind of leadership from their traditional authority.
But look at it, these are the main institutions that are also supposed to help fight the corruption, and they are the ones topping the list of corrupt officials. That's why I asked again, can they be stemmed out? Because then it looks like we don't have anyone fighting the corruption.
Well, it just means that we basically, the same people have to take leadership, because it cannot be that, you know, almost every institution that you expect to fight corruption is perceived as corrupt by an overwhelming majority of. That is a very, very terrible situation. Even for CSOs who, you know, lead this kind of charge, the perception levels are high. I think all of us have to join hands, just as they've done in Galamsey fight, to make this happen. If we don't stem this tide, it's going to be very, very difficult for this country to move forward.
So the former commissioner of Shraj, Emil Schultz, gave out some recommendations. He says appointment of public officials, heads of institutions should stop, but from the government, from the presidency, it should be elected. They should be elected. He also talked about the fact that he thinks government and even the people of Ghana are not taking corruption seriously, and so the cycle continues. Do you think these recommendations can be thoroughly carried through for some effective results?
Not on their own. I think one of the, I mean, we, for example, at CDD have been advocating for many, many years that a lot of these institutions are technical positions, and really it shouldn't be a political appointment, but it's actually getting worse, that more and more of these positions have become political positions that people lobby for. You know, if you concentrate so much power in the hands of the president to appoint everybody, then everybody thinks they have to lobby the president in order to get these jobs. Why are these jobs not advertised for people to go? Because these are public office jobs. You know, so I think that we have to reduce the concentration of power, which then attracts this kind of politicization of the process.
We cross to immigration. A lot of people, a lot of Ghanaians, if I remember, 28% of Ghanaians have the intention of traveling to another country, not even in Africa or West Africa, but outside Africa. Others are also in the process, that's getting their visas or passports. And the reasons given were economic, to escape economic hardships, and for jobs and for security. Why do you think people want to leave Ghana?
Well, I mean, I think the reality is born, you know, from the findings. I mean, this is almost a third of Ghanaians, and actually, if you see the demographic data, particularly on age, the majority of respondents, almost over 50% of them, are between the ages of 18 and 35. So the likelihood that a lot of these people who are also wanting to go are young people, and one of their primary reasons is work or economic hardship.
It shows the unemployment rate we have.
It reflects, and the whole of last year, the campaign, everything was about making sure people get jobs. So I think governments really have to be very serious and focus on creating jobs.
So were you excited to hear the finance minister say that 100,000 jobs will be created?
I don't know the details of that, but if it is public sector jobs, first of all, I don't think it should be in the presidency. If it's public sector jobs, the ministry should open up, you know, applications for people to apply. I don't know that, and I don't think that necessarily is the answer to a very serious unemployment problem. Yes, things like your planting for food and jobs, your 1 million, those kinds of programs. But even that, there are details. What kind of employment are you going to get? Is it sustainable? So for me, that I don't see that as the, you know, I don't know the details, but I don't see that as the answer.
So let's move to vigilantism.
Yeah. Citizens are really worried about this vigilante issue. And it didn't matter whether or not they voted for the government the previous year or they identified themselves as MPP people. They all made it very clear that vigilantism was not acceptable and that people have to be arrested and punished for that. It is really showing that, you know, a lot of these issues, whether it's Galamsey or corruption and so on, if you don't tackle it and tackle it for the benefit of Ghanaians, it will cost you.
More of that in our subsequent bulletins. Then President of the Bono Regional House of Chiefs, Pim Yao Cabrese V, says the creation of the Bono East region is needed to bring major developments to the other parts of the region that has been denigrated for years. Speaking to the media ahead of the meeting with the committee, Yao Cabrese noted that the Bono East region was endowed with resources and social services needed to be autonomous.
It will going to create any disunity. We are talking about certain conditions, like what do you have? If you have this kind of land size, population, and Bono East too, if we have it, I don't think there will be any grudge. If you don't have, you don't have. If somebody has, then you have to allow the person to move ahead to get his region. So there's nothing wrong with the Bono East getting a region and then the Afro getting a region. The traditional area in the Bono East region is almost, we are 16. We are 16 traditional areas, Paramosis. And we are all calling for the creation of the new region.
Meanwhile, former Education Minister and spokesperson for the petitioners from the Bono part of the Bono region, Ameyaw Ekunfi, says he is optimistic that their request will be considered as they have a strong case.
You see, this is going to enhance decentralization. The aim of the government has always been to bring governance to the doorsteps of the people. And to pursue that, I mean, if you have smaller units in the forms of districts, in the forms of regions, that's going to enhance decentralization. And we think that Bono region has landmass that can easily accommodate 3 separate regions. And we think we have a case for that. Because it is so big, the central administration in the region finds it difficult in practical terms to cover the entire area. And when you go to the Bono region, you see clearly that the eastern corner has virtually been neglected. I think if we have an administration that can pay more attention to this remaining part of the Bono region, development will be accelerated.
Former Education Minister Ameyaw Ekunfi. The Commission on Human Rights and Administrative Justice SRAD says it has completed investigations into allegations of corruption in the implementation of Zoomlion's contracts with metropolitan, municipal and district assemblies. The sanitation improvement package is one of Zoomlion's contracts with all assemblies, and payments have been deducted and paid to Zoomlion for more than 10 years. In 2009, a whistleblower from the Tano South District of the Bono region petitioned SRAD, alleging that Zoomlion was colluding with the assembly officials to defraud the state. Why has it taken SRAD 8 years to complete its report?
We got a whistleblower disclosure. I think it was in around 2014, to the effect that Zoomlion, the administrator of the Common Fund, and 138 district assemblies were colluding, conniving to defraud the state. And so we should investigate and make sure that the monies that were wrongfully paid are paid back to the state. So we began our investigations, but we were stopped by a court action. Zoomlion took the position that this is not a matter that the Commission has the jurisdiction to investigate. And so we had a tangle in the court. In the end, we were able to convince the court that Zoomlion got it all wrong. Their basis for challenging the jurisdiction of SRAD was that they are a private entity, and so the Commission can only investigate public officials in regard to corruption. And so once they are not a public company, or they are not public officials, we cannot investigate them. Of course, our position was that we can investigate them, even under the Act, because of the interpretation given to our mandate by the Supreme Court in the case of Baba Kamara and others. I don't know whether you remember that case, the Mabi and Johnson case, in which Baba Kamara then challenged the jurisdiction of the same commission in the same manner, and the Supreme Court interpreted Article 218 to be that, one, anytime the commission is investigating public officials and private bodies, persons, entities are enmeshed in the allegations, the commission should extend its investigation to cover those private bodies and entities. And so that ratio was applied in the High Court to determine that the commission has the power to investigate Zoomlion, not only because they are a private entity and the Supreme Court could go ahead, has given the commission the power to investigate, but that it is a whistleblower complaint. And all whistleblower disclosures, there is nothing about private person or public person. All persons, Ghanaian, natural or artificial companies, are liable to investigation by the commission. So that was the upshot. But of course, there was some unnecessary delay in court. Since then, we have proceeded, and we have covered all the 138 at that time. The district assemblies that were then in existence in Ghana were 138. We have concluded. Our report is being compiled, and hopefully we would come out with our decision.
The story will be following keenly to bring you more information as it develops. Right now, though, it's time for sports on the pulse. Please stay.